I'm going to start by saying welcome to everyone. I am Aswini Weereratne. I'm the chair of the Human Rights Lawyers Association and a barrister at Doughty Street Chambers. And I'm co-presenting tonight's webinar event with my colleague on the executive committee at the Human Rights Lawyers Association, Tetevi Davi, who is also a pupil barrister at 25 Bedford Row. You'll find brief biographies for both of us in the sign-up page for this event, but I'm not going to go through that now. And I'm also pleased to say that we're being hosted on Zoom this evening by Doughty Street Chambers. Tonight, we have the great honor of the company of Nani Jansen Reventlow, who is a leading lawyer in the forefront of the protection of digital rights globally. Tetevi and I have the pleasure of trying to elucidate Nani's work in this fascinating field through our conversation with her this evening. As many of you will know, and I know I'm going to embarrass her, but I'm going to say it anyway, Nani is a Dutch qualified attorney. She's the founding director of the Digital Freedom Fund, which supports partners in Europe to advance digital rights through strategic litigation. She also works to promote collaborative activism in digital rights across different disciplines. She's a recognized international lawyer and expert in human rights litigation, responsible for standard setting in freedom of expression cases across several national and international jurisdictions. Between 2011 and 2016, she led or advised in cases in over 50 national jurisdictions, representing clients before all the regional human rights courts and the UN. Nani is also a lecturer at Columbia Law School, an adjunct professor at Oxford Center for Internet and Society, and an advisor to the Cyber Law Clinic at Harvard University. And I'm very proud to say that she's also an associate tenant at Doughty Street Chambers. So in case you need reminding, our conversation with Nani is of course informed by the fact that digital technology is entering our lives at a frightening speed for private citizens. It's hugely convenient for our daily lives and so much more. We can ask Alexa or Siri or other digital avatars to help us around the house, which may be particularly useful if you have impaired mobility, perhaps. Banking services, travel maps, GP appointments, these are just a few of the vast array of apps offering convenience in our lives. In the criminal justice system, a tag on an ankle can replace a prison sentence or hasten release. We can share and receive news in an instant. Governments and researchers can gather massive volumes of data and information for the purposes of protecting health, especially in the pandemic, and security in the face of terrorist threats. What's not to embrace of these changes? There are costs, however, to this convenience and increasing reliance on digital technology, a cost to ordinary people. Should we care that our digital rights are being infringed? What is the harm to us as individuals or to wider society? What remedies are available to us? We have a large audience tonight with varied backgrounds. Tetevi and I are not experts in this field, and I'm a little daunted by the fact that this is a massive topic and we're hoping to discuss a range of issues from COVID-19 to protests, the use of artificial intelligence, and especially the emerging area of decolonization of digital rights, which Nani is at the heart of. But let's see where the conversation goes. So we do plan to finish at 7:30, but we do have some time to go over if necessary. We'll try to end on time and there will be time for questions as well. So please do type these into the Q&A box. So with that brief introduction, I'm going to turn to Nani and ask her to help us with her journey into this interesting field. And for those of you a little unfamiliar with her, which can't be many, just tell us about how you got to where you are now.
Well, the short answer to that question is that I did not wake up one day and decided that I was going to set up an NGO that was working on digital rights. I did through kind of a little bit of a detour via studying to be a dentist, ended up in law school. And there I got fascinated with human rights and public international law early on in school. And I continued that trajectory throughout law school and then pursued an LLM at Columbia Law School. where it was only reinforced, only to find after that that it was really difficult actually to just find a job straight in human rights out of law school. So I ended up training with a law firm first in Amsterdam, the Brouw Blackstone Westbroek, doing corporate law, but trying to do as much human rights work as I could on the side, and focusing in particular on international arbitration and litigation. And this is something that turned out to be very useful for the next step. Once I qualified, I was very lucky to find a job in London with an organization that's now called Media Defense. At the time, it was still the Media Legal Defense Initiative that defended journalists around the world. And this is where I kind of was able to put together the experience that I gained at the law firm doing litigation work with human rights, and got to litigate all over the world. And developed also my interest in strategic litigation, because I had the fortune of being able to litigate a number of firsts. The first freedom of expression case at the African Court on Human and People's Rights and at the East African Court of Justice, amongst others. And that really got me thinking about strategic litigation as a tool for change. After almost 5 years with MLDI, I spent a year at the Berkman Klein Center, really thinking through like, how can you use strategic litigation as a tool, and how can you make sure that people from different disciplines can connect around those cases? How can you get lawyers, activists, people engaged in advocacy and technology to work together to bring about bigger change? So I worked on that for about a year and launched a project called the Catalyst for Collaboration, which provides best practices for that and case studies. And during that time, the opportunity to set up DFF, the Digital Freedom Fund, came along, and yeah, that brought me to Berlin. Kind of like, yeah, taking a kind of a slightly more distanced approach from strategic litigation, in the sense of not being involved in it myself anymore, but supporting others to do the work. So that's how I ended up here.
Gosh, that is absolutely a whistle-stop tour, but I can already detect in what you've said the seeds of where we might end up talking about things that you're doing now, and the new thoughts and ideas you're having in terms of your activism and multidisciplinary approach to your work. But I suppose it would help those who are listening to us really today, Nani, to really understand what we're going to be talking about today. What do we actually mean when we talk about digital rights?
So digital rights, as we approach it, are all human rights as engaged in the digital context. So there's kind of a traditional or a classical view as to what digital rights are, and that's mostly focused on privacy, data protection, free flow of information online. But we really look at all human rights as engaged in the digital context. So not only civil and political rights, but also, for example, economic, social and cultural rights. And this is something that was perhaps a little bit abstract to some of us until recently, when, of course, the pandemic really confronted all of us to what extent our lives are intertwined with technology at the moment, right? We work remotely, schooling goes remotely, access to essential services, healthcare, etc., goes remotely. So technology is involved in almost every aspect of our personal and professional lives at the moment. So it's important that our human rights are safeguarded in all of those contexts.
Can you hear me? Yes, so I think that's right. So we're looking at issues of then personal data, we're looking at communication, secure communications, and also the control of information, isn't that right? Across a broad range of rights, as you said, not just civil and political rights, but also economic and social rights. And I think, in fact, we're going to come to the pandemic quite soon, but probably that's going to exemplify all of those, isn't it? But is that an accurate way of trying to sum up what it is?
Yes, it is. I mean, I think that one of the things is that it's quite a lot more expansive than people generally tend to think of. But if you think about almost any human rights issue, women's rights, if you think about migration, technology is involved, right? So it's really everywhere. So this divide between like the offline and the online context is a very artificial one, and one that actually doesn't hold true in reality.
Yes, so that's what I was discovering as I was reading, because one has this sense of understanding, say, data protection or GDPR, because that's what affects you in your work, and also understanding what social media might throw up as an issue. But actually, it's much wider than that, isn't it? It just goes into how, as you say, the offline sphere as well. I was just wondering whether there are any cases that that you wanted to just particularly highlight that you've been involved in, or not. You don't feel compelled. But
No, of course,
because you've had so much. I just want to know what you've done.
I think we're approaching supporting about 50 projects by now, many of which will soon finally be up on our website, because we're working on putting together a more comprehensive database of the work that we support. But perhaps interesting to kind of illustrate this idea that, digital rights are everywhere, if I can put it that way. We provide two types of financial support for strategic cases. One is pre-litigation research grants. So that allows potential litigators to explore a specific issue, do further research to decide whether or not litigation is a good option, or if a specific jurisdiction could be better than the other, collect evidence, etc. And we provide grants to kind of like support litigation all the way through the different instances that it might have to go to in order to be successful. So an example of the former is the support that we provided to Worker Info Exchange. And they have been exploring the best ways actually to challenge the business model of Uber, and in particular the rights of drivers in that context. There's a lot of oppression of laborers, right, in the what is called popularly the gig economy, with people who are then officially not employed but working for those platforms, not getting any access to the data that actually control them, and penalize them, sometimes in quite severe ways, without actually having the opportunity to properly challenge that. So Worker Info Exchange wanted to do research on figuring out like what would be a good cross-jurisdictional strategy to tackle those issues. Another case that I can highlight is one that has already completed, that was in the Netherlands, and that concerned a challenge to a system called Siri, not Siri from your iPhone, but the system risk indication system, which was a really interesting example of how governments are trying to kind of like use technology in ways to kind of preempt misbehavior, quote unquote, by citizens. In this case, the government hooked up together a number of government databases and set an algorithm loose that was supposed to detect before the fact if someone was likely to commit benefits fraud. So kind of the pre-crime detection. If you're old enough, you've seen Minority Report. It's kind of like that idea of like, we're going to find out before anything happens who might be doing anything wrong. If you were flagged by the system as such, you were subject to further investigation by the authorities, which of course increases the likelihood that anything would be found. So the system positively reinforces itself. To make things even worse, the system was rolled out in areas that were high immigration and low income overall. So it also targeted a very specific segment of the population. So a coalition of NGOs in the Netherlands and unions decided to challenge that, and were successful there. So the courts there decided to strike down the legal basis for the use of this tool, which is an important precedent for similar tools being rolled out elsewhere. So those are two examples that I can share. I'm sure we can touch upon different ones as we go along in the conversation.
Definitely. So I'm detecting that is that the child benefit case, the Dutch one that you mentioned?
No, that is a different situation. Yeah. There's a lot to be said about the Netherlands. Yeah.
It's surprising, isn't it? When you hear you relate it in that way, you think, you have to think, who thought that was a good idea? But it's
Yes.
interesting that, in a way, do you think that even though, say, the reaction of a lawyer might be that, a bit of shock, that for when you're devising policy, the fact that the technology exists is a temptation to go down that route?
Oh, for sure. And for lots of governments, that is the case, right? I mean, the lure of efficiency and saving costs, etc., is, you know, it's always appealing, but quite often those decisions are then made without properly factoring in the human cost of those types of decisions. And also, I think, without properly reflecting on what it actually costs to correct the errors that are going to be made, if systems are not deployed in a thoughtful and considerate way. Because technology in and of itself can never be the only answer to a challenge.
So, I mean, I think in a way that's almost I would say an obvious problem, the one that you just described in the Dutch system. Perhaps less obvious is the Uber driver situation, because I mean, in just preparing for this, I've come across so many people saying, well, what's the problem with this? I mean, you know, I don't mind pressing yes when I want to give my information if I haven't done anything wrong. But I'm thinking that, and then perhaps that Uber driver situation is a sort of a hidden problem from which you will not consider. Do you just want to say a few words about what the issues actually are? I mean, what is it that the Uber drivers aren't able to access? Is that possible to say?
To a certain degree. So one of the problems is that the way that Uber drivers, for example, are assigned work, or
I'm just going to interrupt to say it's not just presumably that particular company. There are going to be other models of businesses that run the same.
For sure, and it's actually quite interesting. A lot of them are actually incorporated in the Netherlands. So not to keep on talking about the Netherlands, but there've been quite a few challenges also against like Deliveroo, for example, and many others. A lot of it has to do about having access to the same way that you are able to kind of like get a copy of your personnel file somewhere. You should be able to access the data that are held on you. So there's a lot of algorithms at work behind a lot of these platforms to determine who gets to do which ride, who gets to do which delivery, whether or not you're taking too much time or too little time, if you should be penalized for that, yes or no. And this is really intransparent. And for people to kind of like be subject to the will of a company and the algorithms that it deploys, without actually understanding on the basis of which data and which systems decisions are being made, that could have a huge impact on their ability to even generate an income. Because if you're kicked out of the system, you cannot take any rides or do any deliveries. This is hugely unfair, right? And it's I mean, there's a lot of bigger picture issues as well about the whole question as to whether or not people who are involved in this type of work should be qualified as employees or not. But a big part of the work that we were supporting Worker Info Exchange with was really to kind of like enable them to figure out how they could challenge this lack of transparency as to why fundamental decisions were being made about workers on the basis of which processes and which data.
Thank you so much. That sort of, I think, sets a good scene for the breadth of impact of the issues that you deal with. So, I mean, I hope that sets a good scene, and I'm going to therefore just hand over to Tetevi at this point, and let's explore these further. And I know we'll come back to some of these topics again with issues around the pandemic and COVID-19 and what that means in this area. Tetevi.
Nani, so just picking up on COVID-19 and digital rights then. Now, one of the things your organization has expressed concerns about is the so-called digital rights crisis, which has arisen as a result of the COVID-19 pandemic. I suppose the first question is, why do you say that there's currently a crisis in relation to digital rights?
Oh, a number of reasons for that. we're seeing a number of things kind of like develop in the current context. First, there's a huge tendency to kind of like revert to tech solutionist responses to the COVID-19 pandemic. You can think there about health-related tech, so COVID-19 tracing apps, health checkers, but there's also the consequences that we are seeing from the pandemic more generally in us being much more reliant on technology to access healthcare, to access essential services, etc. So, and this forced reliance on technology creates a lot of vulnerabilities. You've seen plenty of examples in the news, obviously, over the past months. Very recently, there was a lot of reporting about, for example, the use of proctoring software in schools to make sure, and proctoring software is basically an automated way to detect if anyone is cheating on exams, right? So this analyzes your eye movements, which way you turn your head, like what do you do? Are you suspicious, yes or no? And, you know, as is the case with facial recognition technology more generally, this turns out to work only well with certain skin colors, aka it works mostly well for white males. So there's a lot of issues there. And then a kind of a final kind of like overarching issue is that the pandemic has provided a really convenient excuse for certain governments to kind of legislate through the back door, if I can put it that way. So using this public health emergency as an excuse to adopt oppressive legislation. And some of that also includes legislation that is purportedly intended to, for example, combat things such as misinformation about the pandemic, but in the end ends up being used to suppress freedom of expression. So.
Okay, and an area that's gained a lot of coverage is the diminishing of digital privacy. So maybe we can just drill down on that briefly. So in particular, there's been a lot of concern about what's termed biosurveillance. Could you just explain what that term means for those who might be unfamiliar?
So biosurveillance is basically the tracking and recording of biometric data. So that can be facial recognition technology. It can be technology that tracks our movements, the way that we walk, the way that we move, but also really basic things such as our body temperature, our heart rate, fingerprints, iris scans. So basically anything that has to do with our bodies, in essence.
Okay, and I suppose within this theme, a very topical issue, and you touched on it just moments ago, is the use of vaccine passports and IDs. Now, here in the UK, people can currently use their NHS app as a vaccine passport when they're traveling abroad. And there are discussions in government about potentially using these kinds of vaccine IDs in pubs and bars and in the reopening of the hospitality sector. What are some of the concerns from a digital rights perspective about vaccine passports and IDs?
So I can flag a few. I think first and foremost is the question as to whether or not it's going to be an exclusively electronic solution, or if there's also the possibility to opt for a paper version, for example. And people could have many reasons, right? Why they wouldn't want to, engage with technology for this. And some people will not actually be able to engage with technology for this. So the question is, are we going to be able to set up two systems that are actually equal in usability, accessibility, and all of those things? So this is one big question. Then there's, the very basic question whenever you are going to kind of like engage with technology when it comes to really sensitive, it's health data, right? So these are sensitive data. How are they going to be stored? How are they going to be kept safe? Who is going to get access to it? And this kind of relates to a next question, which is like, who might get access to it in the future, right? This pandemic might be over at some stage. It might not seem very interesting anymore, like who was vaccinated and who wasn't. But you don't know where this data might end up and in whose hands it might end up and what it might be used for later on. So there's that, and then there's a more active kind of like component of mission creep. We've seen plenty of examples in the past of data being collected or being stored for a specific purpose. And then later on, it was decided that it was actually going to be used for something entirely different. So an example there in a migration context is Weereratne, which was storing fingerprints, right, of migrants to track entry into the European Union, which later access was given to law enforcement, right, to this database. So that's a completely different purpose than for which the data were originally collected. And we've already seen that in the short time span of the pandemic, that this type of situation has already happened in, for example, in Singapore, which was one of the first countries, right, that had a pretty invasive COVID tracking system, which was, the legislation for that was adopted really purely to track the development of the pandemic and making sure that people who had been exposed could be traced and quarantined, etc. But there also law enforcement now is getting access to those data. So these are kind of like things that we have to be really, really vigilant of in any context, but especially here when we're talking about really sensitive information.
Yeah. And of course, Nani, we've touched on issues that go beyond digital privacy. I think one of the areas that your organization has been concerned about is reproductive rights. So could you talk to us about some of the issues with reproductive rights, digital rights, and the pandemic?
Yes, absolutely. So we were fortunate to be able to launch a COVID-19 litigation fund last year to kind of like first response to these types of invasive measures that were being taken, the tech solutionist approaches to the pandemic. And one of the cases that we supported in that context is work that's being done by Women's Link Worldwide, together with Women on Web, which challenged the blocking in Spain of a website that provided information about reproductive rights, including the rights to access to safe abortion. And they argued that particularly in a time when it's really difficult to be able to visit a doctor in person, get advice, get medical assistance, being able to access that information online was all the more crucial. So they're challenging this blocking. This is only just begun, so we have to see where that goes. But that's another illustration of how digital rights are involved in very many aspects of our lives, even if we don't automatically think about it.
Absolutely, it's very broad. Nani, would like to move you onto protests and digital rights. I think that Aswini. Actually, Aswini, did you have any questions? Or
yeah, you know what? I was just going to follow up a couple of questions on the COVID issue, because, you know, one of the things that, you know, comes out from what you're saying is, of course, you know, you use it for, you gather the information on a track and trace at the point when everyone is convinced that they need to save their lives from COVID. And then it gets used in a security context, which is never intended.
Mm-hmm.
So the problem is, though, you know, how do you break that link? And what is the solution, in a way, if really public safety is the driver for the initial collection of the data? And I mean, we're going to come on to look in a moment at some of the more recent cases on some of this, but I'm already going to flag up that the courts are fairly lax on what needs to be done in relation to a public safety pandemic type situation. So it's quite understandable, isn't it, that people would just say, okay, it's a pandemic. I'm perfectly happy. Track and trace is really important. I must give over my information for the sake of the community. What are the safeguards that you think could possibly work there?
I think a lot of it has to do with like actually changing this conversation from one in which there's an assumption made that a technological response to what indeed is a very pressing situation is going to be a helpful response. there is actually not very compelling proof that these track and trace systems are actually that effective in suppressing the spread of the pandemic. So some of the situations in which that type of technology was adopted in Asia, for example, and the pandemic was initially controlled much more quickly, also coincided with very different attitudes towards, for example, wearing masks, social distancing, and all of those things. So the question if an app really was the decisive factor there, that is absolutely not clear. In addition to which, in order to be effective, studies have shown a really high percentage of the population has to actually use the app and has to use the app correctly. So just downloading it doesn't mean that people are also using it correctly. So those percentages can be a lot lower actually than the download percentage, right? And I think that one of the things that should really change is us actually asking, like, so where's your proof? Like, it sounds attractive, but and obviously we all want to kind of like make sure that we are all safe, that we're all healthy, etc. But where's your proof that handing over our privacy, handing over our data is actually going to contribute to making things better for us? So I think that is a really fundamental shift that should take place, is asking better questions and not just assuming that tech is going to save the day.
And Nani, so, sorry, if I can just jump in there, just off the back of that, Aswini. Nani, what's about things that I think have quite clear benefits? What's about things like thermal scanners? And I'm aware that there is an action being initiated in the High Court by Big Brother Watch about the use of thermal scanners. Does that have the same kinds of, I mean, okay, does that have the same kind of concerns as other modes of kind of biometric surveillance, or not? Yes. Something that just appears to tell people what their temperature is in an effort to combat COVID?
Well, the interesting thing there is that there's a lot of medical experts saying that it's actually not that reliable in helping determining whether or not someone has COVID, because there's people who are asymptomatic. Thermal scanners are much less accurate at the moment, at least, than other ways of taking temperature. So through an ear thermometer or the mouth or something like that. So there's a question about effectiveness there. And one of the things also is that at the moment, it's not really clearly regulated, right? And this is one of the things that Big Brother Watch's litigation is going to try and get clarified. Like, is indeed your body temperature, should we consider that personal data, yes or no? And if so, that has implications for how we can deploy instruments like this. At the moment, I think that you know, a bit of advantage is being taken with the fact that it's actually not clearly regulated yet. So it'd be really interesting to see what happens with that case.
You know, that's so. I mean, I'm as guilty as anyone else. So you just walk into a shop and you submit yourself to this, and you don't really think twice about what you're doing with that piece of information that relates to you. And it brings to mind, to me, really the idea of consent. You know, the idea, and that comes from my own practice and my own background, where the issues of consent are absolutely carefully identified, the information that you're required to have in order to be able to make a proper decision. And of course, we understand in a medical context the need for informed consent. Now, I'm just wondering, really, and I'm just looking in my medical textbook, I'm going to say, you know, there's a new test. A doctor is under a duty to take reasonable care to ensure that the patient is aware of any material risks involved in a recommended treatment and of any reasonable alternative or variance. There are other things like, you can only withhold information if a doctor considers that informing the patient of that information will be seriously detrimental to the patient's health. And also, the doctor is not required to discuss treatment if the patient is obviously unconscious or unable to make decisions. I think we might come to that later if we have time. But, you know, so there's a very careful and a carefully litigated set of criteria for informed consent in the medical context and in other contexts. How does that apply here in terms of the consent that we give freely to these situations like thermal scanners and other biosurveillance?
So in principle, consent is a ground on which you can indeed kind of like collect data if the data subject has consented to it. If you look at the GDPR also, that's clarified there as well. But I think a lot of that has to do indeed with interpretation of like what is actually consent. Like, do you actually have a good overview of what you are consenting to? And I think that is not clear at all yet at this point in time, what the exact parameters of that are. There's some initial litigation that's working to kind of like push to get this clarified, and we'll need a lot more. Add to that, like the question, like what are you actually providing consent for, and the risk that data that once you've handed them over will quote unquote travel, right? They might up in other hands. They might be combined with other data sets. The data might be used to create new data on you. So there's, I think that one of the risks is the fact that you just have much less control of what happens once you've handed over certain data points. And it's very important there to also kind of like consider that seemingly innocent data can actually lead to pretty invasive conclusions being drawn about an individual. So yeah, it's difficult to oversee quite often. Like, yeah.
So I'm just going to ask you a little bit more about that, because this whole idea of seemingly innocent data, and I've been reading that even pseudonymized data, so you're handing over pseudonymized data to a medical researcher, again, clearly in the public interest to have medical research done in a pandemic in relation to the disease, but that in the wrong hands or in subsequent hands can be repersonalized.
Yes.
And used to identify individuals. Now, at what point is that piece of information given to the person who hands over their data?
I think that the person in question would only find out about that by accident at the moment. There's that, and also, of course, in the situation that there's big data leaks, when there's an obligation to inform the data subjects that their data have ended up somewhere in the public domain.
So you're talking about big data there. You're talking about like metadata, is that right? So we're talking about location, date of birth, things like that. And I know
I was just referring generally to data leaks, such as, you know, recently the Facebook leak of a couple of years ago actually came to light. There's been a number of massive data leaks also with relation to COVID to COVID patients and COVID data. There was a huge one in Russia where basically an Excel sheet with thousands of people's information started circulating on an app service. So there's, yeah, there's unfortunately all sorts of ways in which that happens. And that's not so surprising because personal data are actually some of the most valuable items to be traded in on the dark web. So yeah, it's worth a lot of money.
So I'm going to ask you that question. I mean, what is it worth? I mean, why so much effort to take our personal data in this? I mean, I think this is what a lot of people don't understand, I would say.
I think the reasons why it would be on the dark web is because of identity theft and all the other wonderful things that you can do once you can impersonate someone else. In the kind of like general marketplace, when we're looking at the data collection of big platforms, etc., it's advertising money. The vast majority of the income of the Facebooks and Googles, etc., of this world comes from advertising. So the more they know about you, the more targeted the advertising can be, and the more effective, and the more they can charge for it, and the more they can sell of it. So, yeah.
So it's thoroughly commodified item. So let's move it on. I'm sorry, I got distracted, I'm afraid. So we were going to move on to protests and digital rights, as Tetevi has already said. And I think we were going to open up this part of the conversation with, I mean, an understanding of the use of social media in that context and the benefits and disbenefits of social media in terms of promoting protests on the one hand and then stifling protests on the other hand. You just want to map out the contours of that debate?
Yeah, so social media can have a wonderfully galvanizing effect, obviously, for protest. The example that we all had in mind for a really long time was the Arab Spring, obviously. But last year we also saw the Black Lives Matter protests around the world that were very much galvanized by social media, right? People use it to organize, people use it to inform each other as to where to go. They also started using it at some point to kind of like instruct each other as to like what to do and what not to do in order to avoid surveillance, which is like the flip side of it all, right? Social media has been used by law enforcement to try and kind of pre-identify people who might be involved in protests, using social media photos in order to kind of like check to verify identities, etc. So it's just mining of publicly available information. So yeah, these are kind of the two sides of the same coin. What is really nice is that the UN Human Rights Committee, I think last year, actually came out also with a new general comment on Article 21 on the right to peaceful assembly. And that very much kind of like integrates the digital component into the right. So it really kind of acknowledges that you can also assemble online, you can assemble in a digital context, and also acknowledges it as a tool to facilitate in-person assembly, and really kind of very clearly instruct states to kind of like stay away from interfering with technology. So explicitly also saying, for example, that internet shutdowns in order to kind of like curb communication between people who are organizing and protesting should not happen.
So one thing, I'm keeping an eye on the time, it's already racing past, but just interested to know in terms of what avenues of redress there are. So say against someone like Facebook, I mean, these in the private sphere, if you're caught up in a social media campaign of that kind and that is been used elsewhere.
So what I was referring to was more police forces actually using publicly available information on these platforms to, for example, identify in-person protesters. So they scrape photos from social media platforms and kind of like run that past like who they see at protests in person to kind of like try and identify individuals. So there, technically, you should be talking to the law enforcement agency that is doing that. Though of course, questions can be asked also from the tech companies if they see this type of suspicious behavior, if there's any role for them to also intervene.
Well, that's clearly an issue that's coming up, isn't it, in terms of the responsibility of those sorts of companies, not just for free speech issues, but also probably in terms of what they do with the information. There have already been some cases on that issue, but I do want to, perhaps let's keep on the protest and the case law that's coming out of protests in that case, and look at the Liberty case. Now that I think that, and I'm going to take it in conjunction with also the Big Brother Watch case in the Grand Chamber, on the basis that, so that case dealt with the regime of bulk interception of information, which is, I think, based on what happened with Chelsea Manning and so on in terms of the handing over of bulk information. And of course, the Liberty case did stem from the use of automated facial recognition technology at a protest, and the use of overtly gathered, so it's slightly, the other side of it, if you like, overtly gathered digital images of the public with a security purpose, if you like, because they had a list of wanted people and other, let's say, undesirables, for want of a better word. And they were extracting biometric data from those attending the protest in order to see whether there was a match. That's putting it in incredibly brief terms. So I've been talking about people are wanted on warrants, suspects, missing persons, individuals of concerns and interests, and vulnerable persons is who they were looking for. And there was no limit on the numbers who may have their facial biometrics captured. And there was immediate deletion of images if they were not being used, etc. So there were some safeguards. So I found the interesting part of this was that I think at first instance, the court said that the safeguards that were used for biometric data processing in that case satisfied under Article 8 the in accordance with the law requirement. But when it went to the Court of Appeal, it failed on that. And the appeal succeeded, if you like, on the not in accordance with the law test, but it failed on the proportionality aspect of it. So I'm going to say, I mean, what it seemed to me was that whilst it can be hailed as a success, obviously, on that point, it felt like really that the whole regime was still being approved of, and the proportionality in terms of the balance between the public interest and the private interests was considered to be adequately protected. It is, and I'm going to just finish this point off by saying that in the Big Brother Watch case, equally, there was possibly, arguably, a fairly technical victory, whilst the regime of bulk gathering of information was not found to be unlawful. What is your view, really, of the role of the courts in helping individuals to promote their digital rights or their rights in this arena?
So I agree that this is a kind of a glass half full, half empty situation with both of these decisions. I do want to say that in the case of Bridges versus South Wales Police, it is important that the court acknowledged that there were fundamental deficiencies in the legal framework, and that also the police had to stop its trial, right, of using this type of technology. The way that I see it is as part of a broader battle to kind of like counter the use of facial recognition technology. The case didn't happen in isolation, right? There's a worldwide debate about whether or not this technology should be used at all. In the US, several cities have decided without a legal challenge to kind of place a moratorium on the use of facial recognition technology because of the prima facie evidence that it was detrimental to large parts of our society. And it's a very active debate also in the context of the draft AI regulation, right? So I do think that because this is a first, it doesn't have to be a perfect decision, but it is a decision that signals something, and it's a decision that can be built upon. And I think that that is important to kind of like look at. And this is also, you know, a view you can take of strategic litigation, which is one that I do have, which is that you can't always get everything done with one case, right? Sometimes you have to chip away at the block. You have to start with the victories that you can obtain and build on that, and this way kind of like carve out a bigger space. So that on the European Court decision, that indeed, yeah, is disappointing in the sense that the big ask, which was to acknowledge that mass bulk surveillance in and of itself violates the right to privacy, was not something that the Grand Chamber subscribed to. However, again, there are some good starting points for further litigation. And the question is, you know, with at least that framework in place as a starting point, alongside consistent lobbying, consistent continued public debate about these issues, can we actually get to that point where we will get the court to actually, you know, turn to that degree? At least at this point, they don't have to turn fully, but they just basically have to, reset their compass to a certain extent. So I like to kind of like take a slightly more optimistic view there than the one that we've lost more than we gained.
Yeah. I mean, I don't generally take that approach either, but I'm just going to push you a little bit on it, because what I see in the South Wales police case is that they need to get their, let's say, what we normally say, ducks in a row.
Mm-hmm.
And once they get their policies consistent, that's going to be clear enough for the members of the public, with the other safeguards, that gives them the green light to carry on using this kind of technology. And in order to change that, it seems to me that you need to see change in public opinion so that the policy can be really affected. And I'm really wondering whether the courts are the right place for that. And I know that you do more than that. So whether is that why you do, you have to join in with the activism as well to change public.
It all goes hand in hand, right? I mean, the way that I like to kind of refer to it is that strategic litigation is one of the tools in the toolbox. You need to kind of be strategic about like what you deploy at the same time, in tandem, following each other, etc. And arguing and issuing court is never going to get you to bring about the bigger social or legislative or policy change that you want to see. You also have to make sure that people are engaged in a public debate about these issues. You need to make sure that those who are able to change legislation are very aware of the issues and get better educated on them. So there's many different fronts on which you have to fight these fights, not just in court, but it is one of the different fronts on which these conversations should be had.
Yeah, and before I just hand over to Tetevi, one of the things that always strikes me is the conflict of interest here in the state. They, they legislate to protect, supposedly, and then they desperately want the information in order to then, in the national security interests or whatever. So there is quite a conflict there, isn't there? And I'm just wondering whether you have any examples of a situation which that those sorts of legislative changes have been brought about by where the courts have been going one way and then policy changes have still been brought about.
I'm going to have to think on that for 1 second.
Yeah,
they are there.
I completely dumped you in that one. I completely dumped you in it, and that was incredibly unfair of me. But anyway, just thought I'd give it a go. Let's just move on to, we want to talk about some algorithms and AI. I'm going to let Tetevi take that over, but we might come back to the South Wales case on that issue as well.
Yeah, Aswini, I was actually just going to pick up slightly as well. I mean, you've spoken about the role of the courts. Nani, just to kind of pick up there, do you place much stock in the corporations themselves? I mean, the Digital Freedom Fund work with the corporations? Because we saw in the wake of the Black Lives Matter protests, some large companies like IBM, Amazon, refusing to sell facial recognition technology to police forces. So is this something you think that, the companies could play a potentially quite large role in? And if so, are they doing that?
The hypothetical, if they could, yeah, sure. If they will,
are they, I suppose?
If they will, I'm highly skeptical about that. I mean, at the time also, if you read carefully what they committed to, it wasn't like a blanket like stop in producing this type of technology, developing it, selling it, etc. So while it was a nice gesture, it definitely wasn't something that was going to end the problem, and also not going to affect their profit margin to an extent that they would really feel it. I think that, yeah, we're still pretty far removed from the companies kind of like having to really address these issues in the fundamental way that they need to be addressed. So I'm sorry, I'm not that much of an optimist there.
That makes sense. Well, the next issue we'd like to talk about is AI-based discrimination. Mm-hmm. And of course, which is linked to the issue we were just discussing. And one of the things that you've been most vocal about is the idea of algorithms automating bias. Could you just explain for those who might not be familiar what that's all about, essentially?
So what we're talking about there is about technology kind of automating replicating and thereby also amplifying the power structures that we see in our societies. And that includes structural racism. So I often actually think that bias is not the best term to use, because quite often it's actually discrimination, it's actually racism, etc., that we're seeing replicated through technology. Bias is actually a nice euphemism for that quite often, which makes it sound like it's a technical flaw that you can solve, which is not necessarily the case. There's a lot of practical issues that kind of like feed into this. There's the overall perception, quite often the technology is neutral, right? Which is not the case. It's designed by humans, it's built by humans, and also it's designed and built in a specific context. So a lot of choices are made actually as we develop technology, from the moment that it's conceived to the moment that it's actually built and rolled out. So if you then think about the not exactly very diverse field of designers and engineers that generally kind of like are developing our technology, their worldviews, their choices, their preferences, their biases are kind of like replicated in many choices that are made in the process. Another issue is that there's an absence overall of multidisciplinary teams. So rather than actually making sure that it's not just engineers and technologists that are looking at these development of these applications, involving social scientists, for example, and others who can kind of bring a different perspective as to like how this technology might impact our lives. So that is a shortcoming. Very often referenced is, of course, data sets issues. And the main problem there is data sets that are kind of like replicating current patterns that we are seeing. So to make that really concrete with an example, if you look at hiring software, for example, that can help filter out candidates, that's often trained on historical data. So that replicates a system in which hiring managers have generally hired white young men from a privileged background, for example. So that will kind of like set the filter, and that will kind of like reinforce itself again, etc. And those are all kind of like slightly more technical kind of like explanations for it. But in the end, it's our societies, right, that create the problems. If you have a society that's racist, that's ableist, that's sexist, the technology that society is going to build is going to reproduce those viewpoints. So, yeah.
And I think
I'm going to just I don't know, Tetevi, there was one more question. I just wanted to move it on because we're running out of time a little bit. I really wanted to get to the next topic.
Yeah, we are actually.
Do you want to ask your question and then we'll move on?
Aswini, you're on mute. Yeah, I think I'll just take one or two more very quickly, because I've just looked myself. We are running out of time. Nani, I suppose just one of the most striking examples in Europe in recent times has been the Dutch childcare benefit scandal, which Aswini touched on earlier, and which I'll just pick up, where many families were wrongfully accused, mostly ethnic minority families, of fraud over childcare benefits. Just very, very quickly, what were some of the kind of automated prejudice at work in that case?
So actually, this is a really good example of what I just said, in the sense that the main thing that was involved there was institutional racism.
Yeah.
So it turned out that not only the tax authority, but over 200 other government instances maintained blacklists, basically, criteria on grounds of which people would be subjected to increased scrutiny. In the case of the tax authorities, people who had double nationality, for example. And the digital rights aspect there is relatively light. It's not similar to what happened in the Siri case, where an algorithm was run over a data set and people were flagged. It was more basic in the sense that queries were made, right? And that kind of like filtered the people out of the system. However, what happened there sets a really important precedent if left unaddressed for future uses, right? Because the Siri system was struck down, but there's currently a proposal to actually create something that's even worse than Siri was. It's referred to kind of like informally as the super Siri system, but that would basically allow for data sharing between not only government services, but also private parties that are engaged in the delivery of government tasks. So the idea that you would kind of like have these giant data sets and being able to run programs over it, like was done in a Siri situation, if we're kind of going to leave what happened in the tax benefit scandal context unaddressed, is going to really kind of like set a pretty nightmarish landscape.
Scary. Aswini, would you like to move on then? Because I'm aware that we are running somewhat out of time. So
don't worry. We have some extra time, Nani, if you're okay, just because there is a topic I do really want you to talk about, decolonisation of digital rights. But I'm going to flag up for people who are with us that there's a very interesting part of the South Wales judgment on training sets in software and algorithms, which led to a finding that the public sector equality duty had been violated in that case, because South Wales Police hadn't really looked at the structural issues arising from the data sets that they were using in terms of identification of race and gender. So that, I think, is a very interesting part of that judgment. But I want to ask you about decolonising of digital rights, because I think this is very much your baby, I'm going to say. I'm sure you're going to say, oh, lots of other people are involved as well.
Okay.
But what is this? I mean, please just, I mean, it sounds fascinating. And I mean, as I understand, it's a new way of thinking about structural discrimination in digital rights, or am I wrong about that?
So new perhaps in what it's trying to do. And so the project has its origins in the fact that if you enter any arbitrary room in Europe where digital rights are being discussed, you're going to find a pretty homogeneous set of people there talking, generally white, generally male, able-bodied, cisgendered, etc., i.e. not a reflection of our society. And that means that the conversations that are being had are very much had from a very specific viewpoint and don't necessarily take into account the very different experiences that each of us have, like when technology is deployed. You just made a really interesting reference to context. And this is one of the things that is really important to keep in mind. Like, you can have perfect technology that might work exactly as it's supposed to work, but sometimes just the fact that you're deploying the technology in and of itself can exacerbate inequalities in our society. And this is something that quite often gets overlooked. Anyways, back to the digital rights field as it currently stands, which has really clear blind spots, right? It's just not well equipped by its composition, in my view, to be able to safeguard the digital rights of everyone in our societies. So what we are working on is setting in motion a process to address the structural issues that kind of create the digital rights field as it currently is and what holds it in place. So we use the word decolonizing process because we want to kind of like make sure that we address the systems of oppression, such as racism, sexism, homophobia, ableism, etc., that have their roots in a history of domination and colonization, and that are being kept in place by structural forces. So rather than looking at things that are usually pursued by like diversity, equity, and inclusion, which kind of like look at things as a pipeline problem and awareness raising, etc., we really want to figure out how can we change things in a structural way to make sure that the field changes, that the people who are working to protect our human rights in a digital context are able to do so for all of us. So.
One of the things that you've, I think, written about is how you differentiate this idea in the way that you structure this argument or analysis, if you like, differently from what we do currently. So, I mean, is this analysis also a critique of the way we look at inclusion and diversity?
So that's a difficult question. So that's almost like a question like, is it better to do something than to do nothing? Let me put it this way. I think that that diversity efforts, as they're usually conceived, sell everyone short. I think they unduly place the burden on the people who are being kind of like thrown into systems to diversify them, to actually do a lot of really hard work. So if you don't change the environment itself, it's still going to be a disproportionately hard battle to fight for the people that you quote unquote include. And then also the question needs to be asked, and like, what are you including people in, right? Are you accepting that the status quo is what it is and that it cannot be changed? So I really am in favor of being more ambitious than that, and actually picking up the harder fight, which is going to be long and for sure will not be done in any of our lifetimes. But you know, as we've been kind of like having conversations about this process, also, this is why we refer to it as a process, also rather than a project. It's something that's going to be continuous work for everyone to kind of keep going. But I think we can be more ambitious than kind of looking at this as a pipeline problem and a numbers game, but really thinking about how can we change ecosystems in a more structural way.
I mean, it seems again that one of the problems with digital rights, certainly from my understanding, is on the one hand it's great, and on the other hand, oh my God, you're really in for trouble. And you know, we see that, and there's been a question about, you know, what do you do about being asked to hand over your information in a COVID pandemic? You ask some questions, yeah, but what more can you do? There's that aspect of it. And then we're looking at this idea that you know, the rights are being developed in a certain environment. I mean, are we really saying this is a sort of like an anti-globalization stance that we're taking? Are we saying that we're creating a dependency in the global south with these technologies that we're imposing on them? Or are we also saying, well, all these communities and societies benefit from these? How do we draw that line?
Well, this is obviously not a black and white situation. I think that just as there are huge drawbacks, right, to technology and to kind of like the shared rollout of certain technologies around the globe, this also provides an opportunity, right? And it actually provides an opportunity to organize and also to resist. One of the things that's actually really interesting about the COVID-19 pandemic and the tech responses that came from governments is that they were all very similar. So, you know, there's variations of COVID apps, there's variations of surveillance tools, there's variations, etc. But in a way, it actually, if you look at it, unites us in very similar battles across the globe. And it's about figuring out like how we can make sure to connect across, you know, jurisdictions and connect those struggles.
So I think I'm just going to ask you to finish that with just telling us what we should be doing then as individuals and in organizations, say in chambers, for example. How do we tackle that?
Well, what I usually recommend is to kind of make sure that you follow closely the digital rights organizations that are in your jurisdiction, because that's where it starts, right? When your government proposes to roll out technology solution 103 to the pandemic, those are the organizations that are going to point out exactly what's wrong with it, what's good about it, what's not good about it for you, for your human rights in a digital context. So you can get informed and you can support them, and you can, you know, add your voice to the choir that's calling for things to go differently. And it does have an impact. I mean, I've seen in several jurisdictions across Europe, there where civil society acted really quickly, asked tough questions the moment that governments proposed a very hurried procurement process to have some of their friends build a privacy violating app. There were, debates in Parliament. The specs were changed. There were more options for citizens to either opt in or out of specific measures. So it is important to kind of like start with that kind of activism close to home.
Okay, Tetevi, you have any more questions on any of this, or any questions that you picked up from the chat box?
Yeah, I was just going to pick out a couple of questions that we've had. Someone's asked, and we haven't quite managed to get on to freedom of speech online, but it was a topic that we planned to cover. Someone's asked, Nani, are there any thoughts on the recent Twitter shutdown and criminalizing its use in Nigeria? What is the wider implication, and how can people navigate this suppression of their free speech?
This is outrageous. First of all,
Yeah.
I could hardly believe it when that happened. I just read a few hours ago that Syrup has filed a case at the ECOWAS court to challenge it. The question is, of course, how quickly that is going to go. But private platform or not, right? It's by now like the town square that we use to share opinions and ideas. So
Yeah.
that should not be possible anymore. So yeah, strongly. Yeah, I'm not in a position to condemn anything, but strongly deplore that this has happened. Absolutely.
Yeah, and I think you mentioned the ECOWAS court, and of course there was the challenge of the internet shutdown in Togo in 2005 that was fairly recently ruled to be unlawful by the courts. I think, as well as people making themselves known to NGOs, I suppose there is also other help, perhaps other types of legal assistance that people could seek out, right, in order to bring challenges in some of these regional courts against these companies and or governments, right?
For sure, because the development of this type of case law is super important, because it's those decisions are still few and far between, and it's really important also to give the courts the opportunity to engage with these issues that are still relatively new for them, so that they can get better at it and also become a bit quicker as they go along in making these types of decisions. So for sure.
Yeah. And then I suppose just a final question is, someone's asked how to protect the rights of citizens of the global south as their data is increasingly pinpointed for future market growth. Do you have any ideas about that?
Oh gosh, this is a really good question, and that touches nicely on the decolonizing aspect. Like the idea of data extraction as being the new mining, if I can put it that way. I'm afraid that I don't have any ready-made answers to offer on that. I can offer some good readings on it, but that unfortunately goes beyond my area of expertise. I appreciate the question.
Well, that's fine.
I wish I were smarter, but
no, I'm sure there's only so much someone can hold in their head. Well, I suppose maybe we can do something like put together a list of suggested reading materials after this talk for anyone who wants to kind of learn more about this. That's probably about all we have time for this evening. We've touched on the increasing threat to digital rights posed by the COVID-19 pandemic, the issue of AI automating bias, even though we're not going to use that expression anymore, automating prejudice or racism or something else that's not a euphemism. And also we've discussed the decolonization of the digital rights field. Nani, if you were just to kind of formulate maybe one key message, and I know it's a very difficult thing to ask, but if you were to kind of put together one key takeaway from tonight's event, what might that be?
So we have a motto, if I can put it that way, for the Digital Freedom Fund, which is that digital rights are human rights. And I would encourage everyone to kind of keep that in mind and stay with this kind of acknowledgement that our human rights are engaged in a digital context, not shy away from it. Just because technology is involved doesn't mean that you don't have a say. You don't have to understand how the technology works quite often in order to understand that your human rights are implicated, and in order to figure out a way to push back. And When it seems complicated, like connect with your local digital rights organization and have them explain it to you. But don't switch off because it's too important.
Yeah, absolutely. And we hope that this conversation this evening has elucidated some of those kind of more difficult concepts for people. Well, that's probably, all we have
Can I
time
just
for.
say,
Nani,
before you finally finish, Tetevi, I was just going to say there are some other questions. As I said at the beginning, this is such a massive area. There's just a wide range of ideas. And I think we will try and put together a reading list. That seems like a good idea to do that, to try and address some of those areas. So bear with us and we will get to that. So other than that, I'm just going to let Tetevi finish up in that case. Thank you.
Yeah, so Nani, I guess we'd like to say a tremendous thank you to you. We're all leaving infinitely more enlightened than when we sat down today. And we hope that this is really kind of a start of a relationship between you and the HR Relay, and that you'll come back and talk to us again. I'd like to thank my co-moderator, Aswini. Aswini, thank you for assisting with this and contributing so brilliantly. And we'd also like to thank Doughty Street, particularly Raimunda, who is behind the scenes and who's been putting out several fires for us recently in relation to this event. So Raimunda, thank you from Doughty Street Chambers. Please remember to join the HR Relay and look out for our next event, which will be advertised on our website and on social media. So yeah, thank you all for attending, and we'll speak to you soon.
Thanks so much for having me for the wonderful conversation.
Thank you very much, Nani.